fact that the government had decided to defer the bill. So I went back to the drawing board and revised my speech. And the point I was making is that notwithstanding the deferment, that was already breach of the Constitution. Because under our Constitution, the power to initiate legislation is vested in the president. But he doesn't have a blank check. So what he has to do is to be able to take into account a number of factors. And one of them is that whenever you decide to initiate legislation, there must be evidence that the president is doing so in the interest and for the benefit of the people. Now, in this case, when you look at Bill 7, in no way does it benefit the people. In no way is it in the interest of the people. And for having undertaken that bill, initiated that bill, he had actually violated the Constitution because he was using his executive powers for purposes other than those intended by the Constitution. So when you have power, power is given for a particular purpose. So you cannot just decide to do whatever you want to do. And I think this is a great lesson. And what was quite exciting was to discover that these issues were actually considered by the court in its judgment, in which the court declared the process leading to the bill as not being in conformity with the Constitution. So in that respect, yes, my point was, even if the bill has been deferred, there was still breach of the Constitution in any case. That's what I meant, yes.
Right. In your speech, you went ahead to say that amending the Constitution is not a routine legislative task, but a solemn act that must be of the highest standard of necessity, legitimacy, and public participation.
That's correct. Yes. For instance, but this one, for some reason, I just decided to read it. Yeah, this takes us back to the issue where the president was, what the president was talking about, to say everything done. The same was a bipartisan product. Both parties agreed upon. Now, what is the reason for wanting to change now? Okay? The same argument we argued against Bill 10 are the same arguments which are still valid today. Okay? But also, even the very idea of proportional representation, the details are lacking. Okay? It would have helped, for example, it's not enough to say there will be proportional representation in a manner that shall be prescribed. If the guys were sincere, they should have, it should have been accompanied by an act of a draft bill which was going to address that issue of proportional representation. You know, it's like, if you are a parent, it's like a child coming to ask you to say, Mom, I'm about to ask something. Can you just say yes? Okay? We don't. Okay? Because you don't know what the child is asking. Now, it's the same thing here, saying, oh, we want to introduce proportional representation and so forth. But the details were lacking. And that is why it became very difficult to justify this particular proposal.
The argument has been from the government, and I think we've heard the minister in charge, the Minister of Justice, also talk about this, saying that the Patriotic Front had amended the Constitution in 2026 before the election. So why is it wrong for the UPND government to do that now?
Yeah, it's always important to know the history. Okay, you have to go back in history. The history is long, but whatever transpired in 2016 started in 91. Okay? If I may just explain. When we made a decision to make a transition from one-party rule to a multi-party system in 1991, there was a general understanding to say, obviously, and this is also something that is important for the president to be able to understand, you don't just wake up to say, I'm going to change the Constitution. There has to be compelling reasons. Yes, Kaunda amended the constitutions, introduced various constitutions several times. If I may go back slightly, you have the Independence Constitution. Why did we have an Independence Constitution? It's very clear. Because in 1964 until 24th December, 24th October 1964, Zambia was a protectorate, okay? Meaning that both your internal affairs and external affairs were being managed by the British government. Now, a decision was made to say it is time to allow Zambia to become an independent, Northern Rhodesia to become an independent republic of Zambia. Now, that is a radical development from being a protectorate moving from being a protectorate to an independent republic. Okay, that situation dictated the need for a completely new constitution. So that's why we had that 1964. So there are reasons. Okay, you can't just wake up because my friends did it, then I should also do it. It doesn't work that way. Anyway, fast forward. In 1969, there was an amendment to the Constitution by amending the entrenched provision in the 1964 Constitution. Again, Kaunda and his administration argued to say, well, this particular independence constitution is not good for development. It is retarding our efforts to develop Northern Rhodesia, Zambia. Now, it is important for us to have the freedom to be able to amend the constitution instead of going to a referendum each time that we want to change even a comma in the constitution. Okay, they made a compelling reason. The issue went to a referendum, then they changed. Fast forward, 1972, Kaunda made a decision to say, a multi-party system of government, which had existed from 1964 up to 1972, he argued that it was problematic. It was deterring development. So they needed a one-party state so that instead of competing for power between political parties, it was better that competition for power was within the party. And that is how they introduced one-party state in 1972. Now, that decision also, a constitution designed for a multi-party system cannot work for a one-party state. So that required a radical a new constitution. Fast forward, the promises were never realized. The country was broke by 1991, and we said, hey, you promised us development and everything else. But what has transpired is a complete destruction of the country. So let's go back to a multi-party system of government, okay? So that too was now different because you can't just polish up a one-party constitution and then make it work for a multi-party system. It doesn't work that way. So you had to re-engineer society. The country had to be re-engineered from one-party rule into a multi-party rule. That is into a to provide for a multi-party system. That's how we came up with the 1991 Constitution. But there was a problem. MMD, which was the main opposition party at the time, was not included in the process. They boycotted the process because they said the majority of the commissioners were UNIP appointed commissioners, and therefore this was already rigged from the beginning. So the two members that were appointed to sit on that particular, on the Vunga Commission, boycotted, decided not to sit. Fast forward, the constitution now is being debated in the assembly. MMD now says, we don't agree with what is provided for, and for that reason, we're going to boycott the 1991 election. Okay? Government had to do something. So UNIP government considered and said, okay, let's reach a compromise. So the 1991 was a compromise constitution to facilitate the election of 1991. So it wasn't a done deal. So there was an understanding from the very beginning that in the event that MMD wins the election, they are going to initiate a new constitution-making exercise. So the process was, the 1991 constitution was not really an acceptable constitution. After the election, indeed, MMD won. Now, for some reason, as usual, power is sweet. But this wasn't doing things until I think even some, if you go back into history, some ministers even decided to resign from government, citing failure to initiate a constitution-making process. Then you have, I mean, the history is very important for the benefit of the president. Right. And who said we hate him or we despise him? We don't. If we despise him, we wouldn't have voted for him anyway with 57% of the vote. So we don't despise him, okay? But we simply disagree with him with what he's doing. But fast forward, in 1993, Chiluba appointed the Monakatwe Constitution Commission. The understanding was very clear. We are working on a new constitution. But what happened? Chiluba abrogated that exercise and changed his mind to say, no, we don't need a new constitution. We just want an amendment. You can understand. So the process was aborted. The understanding from 1991 was to say we need a new constitution. But Chiluba changed his mind and said, no, just an amendment is enough. So that amendment was effected. I think we all know that amendment resulted into Kaunda being barred. Okay. And also, for the benefit of those who may not know, the 50+1 requirement was in the 1991 Constitution, and in the amendment of 1996, it was changed. There were a few other changes. So that Constitution stayed in place. When President Mwanawasa came into office, he too said, hey, wait a minute, we haven't fulfilled the 1991 promise. We don't have a new Constitution. Chiluba aborted the exercise. That is how Mwanawasa had reason to do that, because this was still unfinished business. Then Mwanawasa appointed the Mungomba Constitution Commission, and they came up with a draft. That draft went dragged on. It went to the National Constitutional Conference, because based on the Mungomba Commission recommendation, the idea was that the draft was to go to the Constitutional Conference. That was a debate whether Constituent Assembly or to a Constituent Assembly or Constitutional Conference. It dragged on. Unfortunately, Mwanawasa died. Then Arabi took over. But Arabi did not see that process to the end. So that particular process collapsed. When President Sata came into office, he picked up the ball to say, we haven't finished the 1991 business. Okay? So he decided, I don't need a commission, I just need to appoint a technical committee. And that technical committee did a thorough job. Okay? That is how, after this was now 2012 when it was appointed. By 2015, I think they had finished their work. And unfortunately, Sata died. That process was not completed under Sata. In the 2016 election, the Constitution was an election issue. I remember the current president promising to say, if you elect me, I'm going to complete this particular exercise. Then President Lungu was in the office. He said, he's promising you. Me, I'm going to do it because I'm the president. That is how they decided, and genuinely so, to say, and in any case, don't forget, there was also an understanding that the election of 2016 was going to be conducted in a manner which required the winning presidential candidate to secure more than 50% plus one of the votes. Now the question was, how can we manage this process? Okay? Now, the only option, there were two options. If you had to do it before 2016, it meant you conducting a referendum. Now, a referendum is just another election altogether. So meaning that you're going to have a referendum for the Constitution and then have the actual election. Now, these were going to be very costly exercises. Now, both UPND and PF agreed that the Constitution will be done in two phases. One phase, which involved nothing, was going to be and the Bill of Rights were going to be submitted to a referendum. Now, the referendum was going to be held at the same time as the general election for purposes of containing cost. That was done. That is why you see that the Constitution is amended in 2016. The bill passes in December, and President Lungu gives assent to that particular bill on the 5th of January 2016. So that one phase was done. That phase was completed between PF and UPND. What they didn't agree on never went through. For example, that constitution provided that ministers will be appointed from outside parliament. Both parties rejected that, and that includes the issue of proportional representation that you're talking about. That was rejected. There were a number of other provisions that if the parties are not agreed, then that particular provision falls away. That went through. 5th January, we have the Constitution amended. Then there was a bill that was not subjected to a referendum. UPND campaigned against the referendum. And I remember vividly appearing with the current speaker at one of the colleges. I was for the referendum and she was against the referendum. Okay? The outcome of that referendum was that the referendum question did not get requisite. Therefore, it collapsed. Now, that process, which started in 1991, concluded in 2016. We finished. There is absolutely no reason to continue with the amendments of the Constitution. That chapter is closed. What we should be looking at now is how do we actualize the various provisions of the Constitution. Right. That is why we are saying, no, Mr. President, we don't hate you. You just don't have reason, convincing reason as to why you should amend this Constitution. Because the Constitution as amended is a bipartisan product. Okay, it could not have passed without the support of UPND in 2015. Okay, so it's not about despising somebody. We don't. Like I have said, if we didn't like him, we wouldn't have voted for him anyway. We voted for him. But what we have here is that we have disagreed with what he's trying to do. Right. We disagreed with President, and the same argument we advanced against Bill 10. He said, why do you want to change this thing? Yes, no constitution is perfect, but what we have is a near perfect document, right? We opposed it, we opposed Bill 10, and there is no reason to support Bill 7, okay? Because that exercise is done. We completed it in 2016. Now, when you go to a referendum, you have to respect the outcome of the referendum. You have to respect it. So Zambian people said, we don't want to amend the Bill of Rights. That is why they didn't vote for it. Okay? We have to accept that what we are now supposed to do is to accept the Constitution as it is. First of all, I know people talk about Constitution of 2016. No, we don't have a Constitution of 2016. What we have is a Constitution of 1991, which we amended in 1996 and 14. Now, what is missing in that Constitution? All the articles are clearly outlined. Now, if you don't like something, you can't describe it as a lacuna. Okay? Or if you want something that you wish was there, the fact that it is not there, it does not amount to a lacuna. By the way, you cannot question the legitimacy of the Constitution. You have to take the Constitution as it stands. Now, if I ask you to say, look at the Constitution, you won't like everything. I won't like everything. But the point is, what I like or what you like is inconsequential. It's the law. We are all bound by that. Yes, a Constitution, like any document drafted by man, is imperfect. That is why we have the Constitutional Court. Okay? We have a Constitutional Court because the Constitution itself says, well, there will always be controversies in terms of interpretation and so forth, right? So it has its own internal mechanism for resolving its own internal challenges. And that mechanism is the Constitutional Court. So if you believe there is a problem, you go to the Constitutional Court. And the Constitutional Court will tell you, like we have seen with the judgment, with this. By the way, if this judgment that came out, I can confess, I've been a critic of the Constitutional Court, but I like to say, when something good has been done, we need to acknowledge. This is perhaps the best judgment ever written or produced by the Constitutional Court. This judgment strengthens the standing of our Constitution. Okay? So it is something that I think Zambians should take time to read it. And if only they can read from page 15 to 18, just to understand the dynamics and what the court said. Maybe as we go along, we'll be able to discuss that. But the point is this. We have a Constitutional Court. That was a debate. Is it right for Minister Kasune to start to issue that ministerial statement before people have seen the bill? Right? That was the issue. And the other parties, first of all, I need to commend the lawyers that went to court. Okay, because I'd given up myself, given my experience with Bill 10, I'd given up, really. But I think the lawyers were quite creative in the sense that, and that's the way the law is supposed to work, because you don't go back and do something that your friend has already done. But they took the initiative. They didn't do it. In the case of Bill 10, we waited for the bill. Then we went to court and challenged. And the court said, no, we can't interfere. Now, in this case, tactfully, the lawyers now went before the bill could be presented before the House. Okay? And that is the difference between the two. And the court said, yes, there is this process. Okay? There's something wrong with the way it has been initiated. Okay? And that's why the court said, no, you don't have the right to initiate this process. Okay? So it's a beautiful judgment in that it consolidates our Constitution and supports our democracy. It is something to celebrate. And by the way, it's also important to note, those that are listening, this is the first time in 60 years that the court has stopped an effort to amend the Constitution. We failed in 1972, 73. We failed in 1996. Okay? And in this would be 2019, Bill 10, we failed. The court refused to step up. But Parliament saved the day. So this particular judgment, it is the first time in the history of this country that an attempt to amend the Constitution has been stopped by the court. And that is the way our system is supposed to operate.
Right. To those that are just tuning in this evening, you're welcome to a special edition of Millennium Tonight on Millennium TV. Also, we're streaming live on Ambassador Emmanuel Mwamba's Facebook page as well. We're also streaming live on Millennium TV Zambia on Facebook and on Channel 95 on Topstar. As I said earlier, our phone line will be opening so that you can come through our dear viewer and just be part of the conversation. We move on and cross over to Ambassador, and just so that maybe he can just ask a few questions to State Counsel John Sangwa.
I hope you can hear me clearly. You brought your address on Friday, the 25th of June, 2025, to the Law Association of Zambia and Chapter 1 Foundation organized conference. I think is being cited as landmark, like they are referring to the Constitutional Court ruling that it was landmark. I think you set out priorities that the country must take, because you clearly set out that the nation was in crisis. The unity, fabric of unity was tearing at the seams of disunity, regionalism and tribalism. You cited issues like cost of living crisis, poverty, unemployment, rising debt, and that we are now the 6th poorest country in the world. And you felt that there was no need whatsoever to go to an issue of the Constitution. My second question, and probably asking you, is that they've always, like you fought Bill 10, Bill 7 was using sweeteners, like the issue of MPs, participating at the decentralization level for CDF, like the participation of women, youths, and persons with disability. Do you think these are enough justification for us to hold this constitutional amendments. And my rider is the judgment by the Constitutional Court is very damning. Clearly says the president has breached the Constitution. If a president breaches the Constitution in the manner President Hakainde Hichilema, because they've stated that he breached both sovereign and legislative authority of the people, and he breached Article 1, 2, 5, 7, 8, 9, 61, 90, and 92. Probably just answer those three for me.
Okay. The starting point is this. Normally, when there is a violation of the Constitution, you can't take the president to jail for that. But the only remedy that is there is a possible impeachment. But impeachment is dependent upon the numbers that you have in the National Assembly. And I heard a day or so ago people talking about the fact that they're going to push a motion for the impeachment. I mean, that is not something that is possible because you need 2/3 majority to even start the process, which whoever the opposition combined, even if you put the independents, they don't have that kind of those numbers, and it's very unlikely that the president's members of parliament belonging to the president's party would even support that. So it's basically something that is a non-starter. But there is another penalty, which is what I believe should be the case. When you violate the Constitution, which is what I've argued, and there is an election coming like next year, in my view, you have broken people's trust. Therefore, you don't deserve to be re-elected. That's the penalty you get. And for example, I'll tell you, I voted for the president in the last election. And come 2026, it's not getting my vote because of what has breached that trust. And for the member of parliament, I'm not also voting for the member of parliament that I voted for in 2021. Because he too has breached the trust in the sense that he did not distance himself from Bill 10. So those are the penalties that we have as a people. You may not impeach because that is the job of the National Assembly, but we have the vote. Okay, and that is why in the speech which I read, I was saying that let the election be some kind of a tribunal on Bill 7, and that is one situation that you could. That is one option that is open, and I think for me the public trust has been damaged, and for that reason I don't believe that a person or a president that has breached, because remember, a president takes oath to uphold and defend the Constitution. Okay. Now, when you fail to uphold and defend the Constitution, you have violated that trust. And once you violate that trust, you have forfeited the right to ask me for my vote. That is one way. I can say in relation to the consequences for breaches of the Constitution. I do hope people will be able to hear me correctly. The point is this. We do not need any form of a constitutional exercise. Be it an amendment, a new constitution. Or be it, we don't need that exercise to be undertaken. Because we have a good constitution. What we need to do is to allow people to study and take every effort necessary to understand what it says. The reason